Hello po, welcome po sa ating mga attendees. Hello, Ma'am Lolita, Sir Leonardo. Hello po, Ma'am Christine. Hello, Miss Catherine. Hello po, Mama Dora, Ma'am Ann. Can I see a raise of hands po for those who can hear me? There we go. Thank you po. Thank you, Ma'am Marian, Ma'am Maria. Attorney, can we also try testing your audio din po if they can hear?
Yeah, can you hear me?
There. Thank you po, Ma'am Mary. Thank you, Ma'am Gisette. Sige po. We'll wait for the others. So while we're waiting po, I'll set up na po yung live natin on YouTube and Facebook. Good afternoon po sa mga bagong dating. Hello po, Sir Leonardo. Happy afternoon din po. Saan po kayo galing, Sir? Our attendees, would you mind sharing if saan po kayo from the Philippines? Yes po, for the question po ni Experience Authentic Philippines Incorporated. Yes po, ma'am. Naka-off lang po yung cam niyo, ma'am. And then, naka-mute din po kayo. Good afternoon po. Maayong hapon, Ma'am Maria Legados. Yes, from CDO. We also have from Cebu, Sir Josefino. Yes po, for the question po ni Experience Authentic Philippines Incorporated. Yes po, ma'am. Naka-off lang po yung cam niyo, ma'am. And then, naka-mute. Okay, we will start in a few na po. Hello from Iligan City. Hi, Ma'am Sheila. Hi, Sir Giselle. Yes po, naka-off ka po yung cam nyo. Yung lahat ng participants po is off po yung cam, tsaka naka-mute din po. No worries po. Hello, Sir Benz from Builders Corporation. We'll start at 4 p.m. once we go live na. Okay, we are live. Good afternoon po sa ating viewers on Facebook, YouTube, and Zoom. I am Shane. Welcome po to Mynimo Insights webinar. So for those po, for our participants for the first time po na naka-join ngayong hapon, Mynimo Insights po is a webinar series about the latest career and human resource management news and trends. So I can see po that participants are coming in our Zoom webinar room. We have here Sir Lendy Katubig from Henan Group of Resorts Boracay. Good afternoon po. We also have participants coming from Cebu. Maayong hapon ninyo, ma'am. We have here also Sir Benz from MMI Builders Corporation. Magandang hapon po. Welcome po everyone to Mynimo Insights webinar. We're very excited po with the interesting topic we have this afternoon. It is entitled Employee Relations from Home, Labor Law in a Remote Working Environment. So later on po, after the speaker's talk, we will be having a Q&A portion wherein we will be addressing the questions you have po to our speaker. So feel free to send them here in the Q&A window we have here on Zoom and as well as on our Facebook and YouTube live comment section. So without further ado, may I request everyone to please settle down as we listen to our speaker for this afternoon. Our speaker has obtained his Bachelor of Laws degree from the Ateneo de Davao University in 2012, where he graduated among the top of his class. He joined Angara, Abellio, Concepcion, Regala, and Cruz Law offices as an associate in 2013 after passing the bar examinations and was promoted to senior associate in 2018. He has extensive experience handling employment termination disputes and money claims, formulating company policies and employment programs, labor inspections and audits, outsourcing concerns, the labor aspect of mergers and acquisitions, right-sizing and downsizing programs, union organization issues and strikes. He has successfully defended management actions of several multinational and local companies before the National Labor Relations Commission, the Court of Appeals, the Supreme Court, and other government agencies. He has conducted several lectures on employment matters to ACCRALAW clients. He also has written several articles on employment laws published in a national broadsheet. Further, he is a part of a team of lawyers that wrote the Philippine chapter of the 2016 edition of the International Guide on Labor and Employment, published by Litter Mendelssohn LLP. Our speaker is also one of the firm's representatives to the Davao City chapter of the Personnel Managers Association of the Philippines. Ladies and gentlemen, help me welcome Attorney Martin Luigi G. Samson. Good afternoon, Attorney.
Hi, good afternoon, Shane.
Welcome po to Mynimo Insights webinar. Our attendees po for sure are very excited to have you speak about employee relations po this afternoon, Attorney.
Okay.
Sige po. So, let's screen share for the presentation we have. While waiting for Attorney Samson, again po, if you have questions in mind na po, you can send to our Q&A window and as well as our Facebook and YouTube live comment section.
Hi, Miss Shane. The share screen is disabled.
There you go, sir. Yes.
Okay.
All right.
Yeah, okay.
Well,
Let's begin.
yes, sir. Let's begin.
Okay, see. Thank you, Miss Shane, and thank you to the Mynimo team for the opportunity. Actually, this is my first time to be a speaker in a webinar series, so I would like to thank you. And I would also like to thank the attendees for taking the time to come to this webinar. So I will be talking about employee relations from home, so labor law in a remote working environment. I was already introduced, but please allow me to introduce my law office for a bit also. So I'm a senior associate of Angara Abelio Concepcion Regala and Cruz Law Offices. So we've been in the legal practice for 48 years. We have a head office in BGC Bonifacio Global City in Taguig. We also have branch offices. So it's in Cebu and Davao City. So it's near Ayala for Cebu, and then Davao City, we're here at Price Tower. So we have several practice departments. And then for this session, we will be covering something related to labor and employment. So back again. So specifics. What to do uh, in a remote working setup in relation to your employees. I already saw a question earlier. It's in relation to work from home. So when we say remote working environment, usually two things come to mind. It's first, telecommuting or work from home. These two things are actually different. We have the existing Telecommuting Act for telecommuting. So telecommuting refers to a work arrangement that allows an employee in the private sector to work from an alternative workplace with the use of telecommunication and or computer technologies. So here it's clear when you say telecommuting, there must be an aspect of telecommunication or computer technologies. For example, those working from home um, in the whose work is, for example, programming or a customer service representative who's accessing the internet, or even myself. When I work from home, I use the computer, so technically that's telecommuting. Now, we have other work from home arrangements which cannot be classified as telecommuting. For example, right now, it's pretty popular or pretty common for a few businesses to make PPEs, like the cloth PPEs designer, or somehow made from native native cloth materials. So if they do this, if they make the cloth masks from their homes, this can be considered as working from home, but not telecommuting. So telecommuting is a bit more permanent in nature because there's a law behind this one, and the law was passed even before the entire COVID-19 pandemic. And then work from home, there's actually no specific law covering this one, but this is more temporary in nature, especially if we consider the contents of Labor Advisory 17. Um, Says that the flexible working arrangements are merely temporary. So we will be covering a few things. Like first, if you're thinking of hiring employees who will be working from home. Second, how to deal with the employees who are working from home. And third one is how to sever employer-employee relations with those employees who are working from home. First, when you hire employees, we think of the employment contracts. A few questions come to mind. First, should employment contracts be in writing? How do we sign contracts if they're in a digital form? If you really don't get to meet the other party or the employee because you really want to work remotely, how do we sign the contracts? Should the contracts be notarized? Um, we will also run through general provisions or common provisions that may be included in an employment contract, and then advantages and disadvantages of written contracts. So should employment contracts be in writing? So in general, a contract is a contract in whatever form it may be, except of course if there's a law requiring it to be in some form for either validity or enforceability. So there's no requirement for employment contracts to be in writing. So the easy answer to the question would be no. There's no need for a written or formal contract. So for example, you have a handshake agreement with someone you meet that employer-employee relationship may already start at that point. Emails, email exchanges, SMS exchanges, that could be the starting point of employer-employee relationship. You may already have an employee at that point, even though you think, we still don't have a formal or written contract. There may already be an employer-employee relationship. So if we're saying that if you choose to have written employment contracts at this time, we're all encouraged to stay at home. So how are employment contracts signed at this time? Electronic signatures have already been valid since the year 2000, thanks to the E-Commerce Act. So actually, an electronic signature will tie up the contents of the document to your specific signature. So at that point, you can see any changes, alterations, may it be in the font or font size, you can already detect, and it will be displayed. I mean, you can ask your IT, probably know much better than myself on this, but it will ensure the security and integrity of your document. Now, just make sure that there's a difference between an electronic signature and, let's say, a digitized signature. So when I say electronic signature, it has something to do with the computer program. Uh, with a digitized signature, it's more of you signing in a signature pad. So it may be with a stylus or with your finger, like when you sign for credit cards, or it may be in the form of when your physical signature on a piece of paper is scanned. So that's digitized. So there's really less security with the digitized signature. So it's different from an electronic signature. So another question would be, should employment contracts be notarized? Now, I already mentioned earlier that there's actually no requirement for employment contracts to be in writing. So the easy answer to this would be no, because if it's not required to be in writing, there's really no requirement for it to be notarized. However, notarization will just make it easier to authenticate the document if should you later want to present it later as evidence, for example, in court. It's easier to prove uh, the authenticity and due execution of notarized documents. If you choose to have formal employment contracts and have them notarized, right now, there's the usual requirements of the notarial practice is still to personally appear before a notary public. So let's say, for example, uh, I'm an employer and I'm here in Davao City and I wish to hire someone in, let's say, for example, Cebu, the employee. Um, so I can sign it here, have it notarized here, and then have the prospective employee, sign and have the same document notarized in Cebu City. Now, if we're concerned about going outside, uh, since we're all encouraged to stay at home, there are proposed rules right now pending with the Supreme Court to allow for no personal appearance. Rather, they will send the documents to the lawyers already signed, and then they will have a teleconference like this one and speak to the parties. And then the normal thing, have them authenticate their signature. So at that point, they may ask the parties to sign on a piece of paper just to make sure that the signature appearing on the document before the notary public is the same signature as the one who is talking to and in the teleconference. And then so as of now, I think the proposed rules still haven't been approved. So we can all wait for that. So we're still waiting on that one actually. So general provisions to include in an employment contract, the names of the employer and employee may seem basic, but it's important, especially for for bigger businesses under an umbrella of a group of companies, since they tend to have similar names, at least at the start. Um, I mean, for example, if we say an ABS-CBN group of companies, there will be different corporations with almost similar name ABS-CBN. So just to make sure who the employer and the employee is, the start date of employment, type of employment. So is the employee hired as a regular employee, probationary employee, fixed term employee, project employee, the benefits to be received, the salary, entitlement to leaves, medical, HMO, and other benefits. Normal retirement age, you can actually choose to place that in the employment contract already. Pensions and pension schemes, should you choose to place it there. Brief job title and a description, and then the place of work, or if the employee is required or allowed to work in more than one location, the details of the location agreements. So if you're thinking of hiring employees who will be working from home or telecommuting, you can actually place that already in the employment contract. Other provisions that you may include in an employment contract will be the existence of any CBA, which may affect the terms and conditions of employment, uh, details of disciplinary and grievance procedures, although this may actually be included in an employee's handbook rather than the employment contract. And then intellectual property clause. Usually this is with reference to businesses with research and development or other creative businesses for, let's say, digital art or writing, programming, so that it will be clear to the employee that any output that he or she may have actually belongs to the employer and not and is not, the intellectual property does not belong to him or her. Another one is a confidentiality clause, just to protect the company's secrets. Non-compete clause. So when the employee leaves, usually it says that he or she may not go to a competitor, or he or she may not put up a business in the same field. And then non-solicitation clause, for a certain period after the severance of the employer-employee relationship, he or she may not contact former clients, customers, suppliers, and then try to solicit business from them. And then non-recruitment clause. So just to prevent former employees from poaching your employees or poaching talent from you. So those are some provisions which you may include in an employment contract. So advantages and disadvantages of written contracts, proper documentation. So at least it will be clear. The terms and conditions of employment will be clear. Later on, if there will be any dispute, it can be used as evidence. It can be used as evidence, let's say, for example, in the NLRC or in the courts. At least you will be amply protected if the contract is written properly or it's complete. Another advantage is the ability to control former employees' acts even after the employment has been severed. Now, we made mention earlier of specific provisions you may include. So the purpose of let's say, the confidentiality clause, non-compete clause, non-solicitation clause, and non-recruitment clause, these clauses can actually remain in force even after the employer-employee relationship has ended. So the non-compete, non-solicitation, and non-recruitment clause, somehow this is taken on a case-to-case basis, but I've seen cases say that these are valid as long as these are limited as to the place and time. So as to time, I've seen it being validated for a period of 2 years. I haven't seen cases that have extended to more than 2 years, but these have been um, held as valid. So you can actually control the acts of former employees. Another advantage will be if there's a provision in your employment contract which has been violated, you can already specify liquidated damages. So it's, what do I say? If you, let's say, for example, you violate the confidentiality clause, you revealed company secrets, you can already say that any violation of the contract, you will be made to pay, for example, 100,000 pesos. That's just an example. So you no longer have to prove how much you suffered in terms of damage. You just say, this is the provision. The employee agreed to this one, and he also agreed to pay damages in this amount. Okay. Another disadvantage, a disadvantage of this one is, of course, when there's proper documentation, um, you're also tied to the written provisions of the contract. So if you say to the employee that so and so, and then there will be a disagreement between the both of you, you're tied. When I said earlier that the document can be used as evidence, please consider that it can also be used as an evidence against you in case that there will be any dispute and there's a provision that's in favor of the employee. Okay, and then in case, another disadvantage is in case there may be ambiguities. What do I say? There are certain provisions that are unclear in the contract. Please remember that in the labor code, any ambiguity is resolved in favor of labor. And then another one is in the civil code. There's a concept of contracts of adhesion. What is a contract of adhesion? It is a contract that's purely made by one party. So usually when we have employment contracts, these are forms, pre-made forms made by the employer or the HR, and then all the employee has to do is to sign it. So if there's any ambiguity there, um, it's strictly construed against the person who drafted it. So there's a big chance that the person who drafted it is from the side of the employer. Okay, now you already have employees since there's already an employer-employee relationship and an employment contract, whether or not it's in a formal, written, unwritten form. Okay, so we I go back to telecommuting since this is the one that's actually covered by a law. As I said, most work from home policies are based on the Telecommuting Act. So those who are using devices for their work. Okay, so for the Telecommuting Act actually requires that there be mutually agreed upon policy between the employer and employee. So they will have to agree to policies with reference to eligibility. So for us, we're allowed, even before the COVID, we were allowed to take days where we're working from home. For us, it was we must have been employed with the firm for at least 2 years. So 2 years and up, you're allowed to work from home. So it actually depends on your own policies. Applicable code of conduct and performance evaluation. So let's admit it, with work from home, it's an entirely different setup from office-based work. So how you monitor employees, how you will evaluate them, you need to agree on that beforehand. Appropriate alternative workplaces. So will you be required to have a well-lighted home office? Will you allow the employees to work from, let's say, a coffee shop, a beach, or something similar? Because if for us, since we're in the legal profession, we're actually not allowed to work in coffee shops, especially if we connect our devices to the coffee shop Wi-Fi, since there are security issues and other data privacy issues. Okay, and then you can also agree on the use and cost of equipment. More on that later. The work days and work hours. So you need to agree on that one as well. Other matters which must be discussed, the conditions of employment, compensation, and benefits, particularly those unique to the telecommuting employees. For example, if you want to give out internet or communication allowance, so better that you place it in your work from home policies. And then non-diminution of benefits. If you have employees who are based in your office, based in your physical office, and then you transfer them to a work from home environment. So just make sure that there's no diminution of benefits. So their benefits, their pay, their salary, and others will remain the same. So it will not be unilaterally decreased. Okay. And then occupational safety and health. There's really, so if you're cooped up at home, it's more on the mental health aspect rather than occupational safety. And then observance of data privacy policy, we will also discuss that a bit more later. Dispute settlement, what happens if there's any misunderstanding or dispute between the employer and the employee? Will you immediately refer it to a certain person, the president, escalate it to another person? This must be agreed upon. And then termination or change of work arrangement. So actually, the Telecommuting Act is optional, both um, as to the employer and as to the employee. So if either party it does not want to implement a telecommuting arrangement, you can have it terminated at the option of either party. Okay, so back again, requiring work equipment, because we mentioned earlier that the agreement, you must include the use and cost of equipment. So it must be agreed upon by the employer and the employee. There's no immediate requirement that it should be shouldered by the employer. There may be a cost sharing, or if the employee already has, let's say for example, a laptop that he wants to use for work, uh, he can use that one, his personal laptop, if he or she wants to do so. Now, the only requirement in the Telecommuting Act is that without additional cost, the employee should receive appropriate training on the technical equipment at their disposal and characteristics and conditions of telecommuting. So that's the only portion that says without additional cost on the part of the employee. As to the training, there's no specific portion that says without additional cost, have the use of office equipment. However, ideally, it's ideal that the company will provide for the equipment free of charge, and it should be dedicated solely for work. We will see later on why this is. Now, of course, it's a different setup when someone's working from home. So the rules of conduct, an employer may pass rules and regulations as to the work. Okay, it's part of management prerogative to issue rules and regulations in relation to work. Now, the question here is mostly in relation to the monitoring of work. So there are actually two mindsets. If the employee is working from home, is no longer in the office, you still require a body and seat mentality. What does this mean? We require the employee to be in front of his laptop from 8 a.m. to 12, and then from 1 to 5. So it's the same. You're still required to do your work at these hours. It's just that you'll be doing this at home. Or an output-based mentality. So it doesn't matter to us what time you work as long as the job gets done. So for me personally, if someone's working from home, what's important is communication rather than have the employee in front of his laptop or computer for 8 hours a day. What's important is the output. He does the work well. Uh, Communication. He's available when you need to call. For example, some offices have 15 minutes, have meetings 15 minutes a day. So it's either mostly this is done through Zoom. And then I've seen other companies have designated core hours. So from 10 a.m. to 2 a.m. From 10 a.m. to 2 p.m. you must be available to pick up any calls, answer any emails, so you can address any questions by either coworkers or clients, customers. And then but you can still do your work outside of these windows. Inform your employer and your coworkers if you will be unable to communicate or to reply to them, especially during these core hours. Now, um, monitoring of work. I've seen a few employers really do this one since they're still doing the body and seat mentality. So they have surveillance apps. They really have valid reasons why they have these surveillance apps in place, um, in order to make sure that the employees are doing what they're supposed to do, to ensure that the productivity levels are maintained, to protect intellectual property, to maintain the integrity of hardware and software, especially if the device that's being used belongs to the company. And then for documentation and protection, in case there will be a dispute or there's a complaint from the client, you have documentation or adequate protection, at least to show as proof. Uh, there are those especially in, okay, as onto the surveillance apps, there are different types of apps or software here. First one is they can keep track of what they type, so keystrokes. Apps can record internet activity. You can monitor what sites they go to. Some apps can take random screenshots or videos at certain times. You can have access to your employees' webcams, and then you can have the capability to see what the employees access and what files have been accessed at what time and at what date. You can monitor the employee's physical location using GPS. And then you can measure the employee's productivity, uh, such as you will see the computer's idle time, how long an app or a piece of software has been open. So if the computer has remained idle or if one app has been open for quite a long time. So the question with all these things, what these softwares can do, the next question will be, are these things actually allowed? Is this not an intrusion of the employee's privacy? Um, if you're really monitoring work, if you're going into the computer of your employees. So there's actually a 2011 case by the Supreme Court, which said that work-related searches are merely an incident to the primary business of a company. So this actually involved a civil service employee. Who was in the legal department, and then there was an anonymous complaint against him. The complaint was that the employee was moonlighting, accepting cases, and then some of these cases were actually pending with the civil service commission itself. So what happened here was that the regional director instructed her subordinates to go through the computer of the one being complained. Of course, at this time, um, the one being complained was out on leave. So they went through the computer, they went through all the files, and then at this time, I think it was still diskettes. So they went through all the files in the diskettes, and then really they discovered incriminating evidence that the employee was engaged in moonlighting, and some of these cases were in relation to civil service cases. Now, the employee was later on fired, and then he challenged the finding. And then one of the arguments he said that was the evidence against him was not valid because there was no warrant against him. So here the Supreme Court um, said that you cannot possibly expect that the employer to still obtain a warrant since the search is really in relation to your employment. And then also let me so we have clients who are engaged in the calls who are in the call center industry. So some of the agents who um, so all of these computers are actually monitored. So the calls are monitored for usually it's for quality, but uh, they're also being evaluated based on the calls. And then some of the clients they had the software where they could record the screens, what is happening in the screen of the specific call center agents. So when the client reviewed some of these videos, the client saw that some of the agents were intentionally dropping the calls at the beginning, or they put the customer on hold for a really long period of time and then eventually just drop the call. Worse, um, some agents would read pornographic materials on their desktop computers while on work. So these were actually caught on video and they were dismissed based on the evidence. So these monitoring is really allowed. So recently, well, it's in 2018, the National Privacy Commission issued opinion number 2018-48, um, which said that the employers may monitor employees even in a work from home setup, but this should be balanced with the rights and freedoms of the employees. And then um, the National Privacy Commission said that monitoring office issued computers may be allowed as long as it is transparent to the employees and that they are notified that they are being monitored. There's just a preference to less privacy intrusive means of monitoring, which should be considered by the employer. So here, the National Privacy Commission, so this is the commission that was put up to make sure or enforce the Data Privacy Act. So they're saying that there's no intrusion of the employee's privacy. You can monitor their work even if they're working from home if it's in relation to an office issued computer or device, and then the employee knows that they will be monitored. So if they're using an office issued, let's say, laptop, and then they know that they will be monitored, so they won't have any reasonable expectation of privacy. So in this regard, when you issue let's say an office laptop to an employee, you can also in the receipt, they will sign for it. You can also ask them to sign that they consent that they will be monitored. So it will be easier to prove later on in case of any dispute. Now, data privacy issues, because the Telecommuting Act really says that it's the responsibility of the employer to protect uh, or the data privacy, especially if you will be processing personal information, sensitive personal information. So it's still the responsibility of the employer to protect the information. So in this regard, the Telecommuting Act requires employers and employees to agree on a minimum standard. Uh, you can implement measures. For example, some of these measures may be to include disabling of hardware, modification of the USB access, restrictions on the use of external cloud-based storage by work-from-home employees. So um, with these measures, for example, you will be disabling the USB or internet access. So it's really easier to make all of these restrictions if if the modifications will be made on an office laptop or an office device. It's quite difficult to make all of these changes if it's the personal laptop of the employee. Next, employers can secure personal data processing systems used during work from home when you provide information and communications technology equipment, support facilities, mechanisms to the employees. So there should be a data protection and privacy policies to guide your work from home employees. For the government, so this is not for us, the heads of agencies shall ensure that employees have access to or is provided with communication equipment or facilities. So, mas mabuti pa sila. May suggestion ng National Privacy Commission that they be issued laptop computers, internet telephone, mobile phones, etc. to do their work. And then, so if you want to implement a body in seat mentality, a fixed hours, let's say from 8 to 12 and then from 1 to 5, please take note that the hours of work will still apply. So the total number of working hours of an employee should not exceed 8 hours. So if it's in excess of 8 hours, you will be made to pay overtime. And then compensable hours worked uh, include all the time during which an employee is required to work to be on duty or to be at the employer's premises. So this is not the employer's premises, but just to be on duty or to be at the prescribed workplace. All the time during which an employee is suffered or permitted to work. For example, um, let's say somehow some call centers manage to make a telecommuting arrangement with their employees. Some, I'm not sure if they're still doing so right now, but during the ECQ, some employees were made to work from home. So if you require your employees to work from 8 a.m. to 8 to 5, the usual 8 to 5 p.m., and then there's really no call routed to them, but they're in front of their computer, they're ready to take a call. So this is considered as compensable hours since they're made to wait. This is considered as they're being permitted or suffered to work. So they should be compensated for all of this time. Now, if you're doing this approach, um, it will be still be the same break equivalence, a meal period of not less than 1 hour or 60 minutes, subject to certain exceptions, and then a snack break of 2 minutes. Same. So this is still the same, the break equivalents. And then, okay, these are already with how the employees are, how you will have relationships with your employees. Now, I saw the question earlier in the Q&A. How do we serve memos and disciplinary sanctions in a remote setup? Because, I mean, the gold standard, it's still personal service. If you can serve the memo, the NTE or the NOD, notice to explain, or the notice of decision, uh, it's better that you still ask the employee to personally receive. You can have a messenger go to his or her house, serve, and then ask to receive. Now, if the employee does not want to receive the memo, but it's still given to him, just doesn't want to sign for it, you can have witnesses sign to say that refuse to receive and then sign. Um, and then if personal service is not possible or if the employee refuses to receive, I I would like that the memo to still be sent through registered mail or express courier. So registered mail, this will be through the post office, and then the movement will be documented by the post office. Express courier, most of these things will be sent to the last known address. So that's the address in the employee's file, the 201 file. And then um, these things were actually quite difficult during the ECQ, considering that the post office was closed at this time. And then as to the express couriers, you would never know when the recipient would actually receive the package, because we're not sure if the delivery personnel can go through different checkpoints, the choke points, and then as to the so there's actually quite a difficulty for employers who chose to sever employee-employee relationships, since it's not instant at the time. So, what do you mean by that? For example, for employers who wanted to retrench employees, there's a two-notice rule. One is to notify the Department of Labor, and the other one is to inform the employees. So 30 days before the effectivity of the termination. So if you're going to serve these things through registered mail or express courier, the notices, and it will say, uh, especially with discipline, you will say that it's effective upon receipt. You may not know when the employee actually receives it or when he or she may be terminated. And then, so other possible modes of service through email and SMS. Now, I had a case um, where the notice of termination was sent by the HR to the employee's email. Now, the bad thing about this, because all of their communications were actually made through email. The notice to explain, sent through email. The employee responded through email. And then when the decision time came, the notice of decision was also sent through email. Now, what the what the HR did here was that the email was sent to the employee's work email, not to the personal email. So what happened was that sent to the work email of the employee. And what they do, or I think what it wasn't anticipated, that the email itself or access to the email was also cut off, because they thought that he was no longer an employee at that time. So there was no proof that the employee actually saw the notice of decision. There's no proof that he was informed of the decision or informed that he was already terminated. So this was a predicament on the part of the employer. And then there's really no set rules as to how to serve the email. So I'm sorry, as to how to serve the memos and disciplinary sanctions. there's no prohibition that you cannot send it through SMS. So if you can avail of one or two of these different modes of service, then why not? Because email, there's a possibility that the employee is not always accessing his or her email. SMS, same. They can probably say that he or she did not receive it. But if you resort to more than one mode of service, then it's easier for you to say that you exhausted all the possible modes of service, or if you tried your best to really serve the memos and other notices to the employee, even if they're in a remote setup. Now, I've come to the end of my presentation, so I really wanted to have a short presentation. And then, I talked to Ms. Shane about this yesterday. I really want to maximize the question and answer portion. So we will be addressing your concerns at this time, Ms. Shane.
Yes, sir. Yes, Attorney Martin, thank you very much po for that very insightful talk. So I guess we will now start answering the questions provided by our attendees. So first, we have a question from Denise. If the devices used for work from home, like laptops and smartphones, are personally owned by the employees, what are the limitations of the employer to check on work productivity through those personally owned devices?
There's what I showed you earlier was the advisory opinion. It speaks of office issued computers and devices. There's still no issuance with respect to personal devices, but since there's no issuance saying that it's not allowed, I would hazard to say an opinion that it's allowed, but just make sure that the employee is aware that he or she is monitored. So I believe some of the not formal employees, some some of the employees, like I know there are virtual assistants. They have applications that will uh, determine whether or not um, they're idle or if they're really doing work. So um, it's not really, there's no clear cut rule to say that it's prohibited to monitor employees who are using their personal devices. So what I suggest at this time is, if there's an arrangement like that one and then the employee agrees to it, make sure that the agreement is documented. So have him sign, let's say, an agreement that he consents to being monitored.
All right. So thank you, attorney. We have here another question from Romel. Can we impose webcam surveillance to employees while at work, even if they complain about invasion of privacy?
Webcam, if you're going to do webcam, I mean, you must really balance things out. If it's webcam, there's the National Privacy Commission uh, they have, I saw it, it was a recent frequently asked questions, and I believe uh, this was there. You must balance the right of the employee to privacy and then your right to monitor the work. So if you say that you will use the webcam to monitor whether or not he or she is doing work, I believe from the answer of the National Privacy Commission, from what I recall, I mean, you can check on this one later on. Uh, I think it says that if you're going to use the webcam, it's a bit too much. It will already be stepping on or infringing on the privacy of the employees. That's what I remember.
All right. Thank you, attorney. So we have here a question from an attendee. He or she sent a article from GMA Network that says employers should shoulder extra expenses of workers amid work from home setup by Dole. So here's the question. There are employees who think that subsidizing internet connection is part of employer responsibility due to this article. Is it mandatory?
Um, let's say, for example, the internet connection, there's really no provision in the Telecommuting Act that requires the employer to shoulder, let's say, the equipment or the internet. It will be good practice for the employer to shoulder the, let's say, for example, internet connection for the to shoulder the devices, laptops, computers, webcams, and whatnot. It will be good practice, but there's really no requirement. Now, if you say there are articles, I believe that I also saw the same articles. There may be interviews with, let's say, uh, not USEX. I believe it was assistant secretaries or something, not the secretary, not Secretary Bello himself. So there were some articles saying that it's the responsibility of the employer. There's really no provision that it's the responsibility of the employer. If we're talking about the Telecommuting Act, it's really by agreement by the employer and the employee.
Okay. Thank you, attorney. We transfer now to some questions regarding contracts. So we have here a question. What if the employer would like to change all contracts of regular and probationary employees into an independent contractor agreement or like a project-based employment? Is this legal, attorney?
Medyo mahirap ang question. Actually, kasi if you're going to do that, they're regular employees and then technically you will be terminating their services and then enter into new agreements, may it be project-based or fixed-term employment. Um, you may do so at your own risk. So if you terminate the employer-employee relationship, you can ask them to resign. If they will not resign, um, you cannot force them to resign, obviously, since it will fall under constructive dismissal or illegal dismissal. However, if you will terminate the employment by, let's say, redundancy or retrenchment, and then pay them separation pay, and then you want to take on them as project employees or fixed term employees. Let's say you're able to do it. And then for a year, for 2 years, there's no question about it. But later on down the line, there will be a question and then they will challenge that past decision to convert them into project employees, fixed term employees, or consultants. They can actually challenge that, and then the facts will be taken on a case-to-case basis. So you will be taking on the risk that later on down the line, there will be a determination that they're still regular employees. And then the act of converting them may be seen as a mere ruse to go around their right of security of tenure. So it will still be a case-to-case basis.
All right. Thank you for answering that, attorney. We have here a question regarding sanctions. So, can the employer sanction an employee who is doing freelance work after shift, where in fact it is expressly stated in their employment contract not to engage in freelance in whatever form?
Freelance, yes, you can actually sanction them, especially if it's in the employment contract that they cannot moonlight or the like. You can impose your own sanctions, especially if it's in the policies, employment contract that it's not allowed.
Okay, thank you, attorney. So, a question here about monitoring our employees. Absent the monitoring system, is it legal for employer to reduce the pay, say 60%, considering that work from home scenarios also do not guarantee that employee is 100% working 8 hours per day?
So you will be reducing the pay.
The pay.
That's what I get. Pero I mean, if there's also a corresponding reduction as to the work hours, it's possible because if you look at the labor advisories um, on job preservation, it says that the employer can do flexible work arrangements, or sometimes there's aside from work from home or telecommuting arrangements, you can actually reduce the hours of the employees. I mean, some employees have reduced work days or work hours, so they're just paid uh, in correspond their appropriate pay corresponding to the actual days or hours worked. So it's like the concept of no work, no pay. So if their actual work is reduced, then then there's a corresponding decrease in the pay, then that's allowed. But if you're saying the pay is the work is the same, then they should be paid the same amount. But if they have a big, let's say for example, they have a big salary, the labor advisory also says that there can be a negotiation between the employer and the employee to reduce the salary for a temporary time, as long as the employee agrees to it. Temporary, I think the period was 6 months, maximum period of 6 months.
All right. Thank you for the clarification, attorney. Before we proceed with the next question, I would like to answer some questions provided here in our webinar chat. You have questions regarding Attorney Martin's presentation. Yes, we will be providing the presentation. We will be sending it via email tomorrow. This will be sent to all attendees. Yes. And also, Attorney Martin, would it be all right that we can cancel the screen sharing so our participants can fully see our web cameras?
Yeah, yeah.
Thank you so much,
Wait,
Attorney.
let me. Wait a minute.
No worries. Yes, Miss Jane, we have a question for here. Yes, we will be sending the presentations to your email.
Screen. Wait.
Maybe I can adjust it
Yes,
from my.
please.
There you
There
go.
you go. Sorry, sorry.
Okay.
Thank you.
Thank you so much. Thank you so much, attorney. So let's proceed to the next question. We have here a question regarding overtime. Will we consider it as overtime if employee lost their internet connection, which also equates to no work hours, and have them extend to cover the lost hours?
If working from home and then you lose internet connection. So if you're not actually working, they don't have to be paid. Um, so the normal work days is 8 hours per day. So if let's say you lose internet connection, and then let's say you lose the connection for 4 hours, so you will be made to technically extend, but there's really no extension since the work will still be 4 hours, and then there's a break of let's say another 4 or 5 hours for the loss of internet, and then made to work for the remaining 4 hours. So it's still the normal work day. So there's no overtime pay to speak of. The closest thing I can relate this to was there's actually cases previously in relation to yung uso pa yung brownouts, I'm guessing. Yeah, I think it was in the 90s. So there were rules that said during the brownout, if you're not really required to work, you can go out of the office at that time. Um, then you're not required to work. So it's not counted in your normal work hours. So I'm guessing it's the same. If you lose your internet, you cannot perform work at the time. That's not considered or counted in your work hours. So the quote unquote extension is still part of your normal hours and not part of overtime.
All right. So I think it was a pretty clear answer from Attorney Martin. So Attorney, I think we We also have overtime right now. So would it be all right if we answer last 6 questions from
Yeah, no
our...
problem. No problem.
All right. So let's proceed to the next question from Alder Playo. What is the maximum period or months we can give to the employees if requested not to report for work because of COVID-19?
Maximum period. Well, it actually, if the employee refuses to report for work,
Yes. Yes. The question was about the employee. Oh, wait. The question was about what is the maximum period or months they can give as employers to the employees if requested not to report for work because of COVID-19.
okay, I'm not sure as to who's making the request at this time. So if it's actually the same rules, if you're an employer in an industry that's allowed to open, let's say you're in MGCQ or GCQ, you're already allowed to open, but you feel like you will not be getting significant number of business. For example, let's say you're in the business, you have a preschool, for example. I don't expect kids to still enroll in preschool. So you may have teachers and other personnel. You choose that not to open at this time. You can place them in the normal floating status for 6 months instead of laying them off. For 6 months, they will be placed on floating status, and then you do not have to pay them during this period of 6 months. So that's the usual 6 months. But if we're talking about if the employee does not want to work, but you're already allowed to open and allowed to operate, um, but it's on the part of the employee, he or she does not feel safe, does not want to report to work. There was a labor advisory earlier in the year, labor advisory 1, I think. It's actually issued more in relation to the Taal eruption. So it says that an employee cannot be terminated or disciplined if he or she does not want to report for work due to a natural or man-made calamity. Now, with the presidential proclamation, I think it was 929 back in March 16, it declared COVID-19 to be a calamity. So for a period of 6 months, it was for a period of 6 months. So during this time, you cannot terminate an employee if he or she refuses to show up for work because of COVID.
Okay. Thank you, attorney. So we have here a request from an attendee. Would you please tell us how are administrative cases or proceedings being addressed to at this time of pandemic?
Actually, it's still the same. I mean, you still have, let's say, for example, you have an incident report, and then you will still ask the employee to explain. Uh, Notice to explain. You will outline the facts uh, or the allegations against him or her, the possible uh, policies or portions of Article 297 of the Labor Code which may have been violated, and then ask him or her to explain. Now you can have actual administrative hearings, which is made easier by, let's say, for example, Zoom, another um, software, and then the usual notice of decision afterwards.
Okay, thank you so much, attorney. So we are down to our last 3 questions. This is a question from Christopher. Before the pandemic lockdown, we are giving our employees a meal subsidy if they report for work at the office. We are now working from home on a temporary basis and no meal subsidy is given. Are we liable to diminution of benefits? The subsidy is not part of the contract under allowance and benefits.
Okay, so diminution of benefits. Um, I mean, if the benefit is really if you show up to work, we will give you a meal. Now, I would hazard an opinion that since you're working from home, you're not at the office, we can actually say that you're not entitled to a meal since you're not working at the office. The circumstances are different. If you're in the office, we give you a meal. Since you're not in the office, you're not entitled to it. I mean, the same thing actually applies to us right now here in the office. So I would say that there's no diminution of benefits since the benefit is you're entitled to a mail if you're working in the office, since the same situation uh, does not since the same scenario is not it's not the same as when you're just at home. I mean, you will really eat lunch wherever you are, sunk cost. So I would say no. There's no diminution of benefits.
Okay. So we have our second to the last question. Is it just legal, attorney, if an employer will add in the new work from home contract that whenever they will go a wall in a day, they will be asked to pay a monetary penalty? And also add in contract that whenever they go early separation from the company, they get to be penalized? I actually personally see it as an unfair in the employee side.
What was the question again, Ms. Jane? So if the employee
Oh, there you go. So the question, attorney, was all about if an employer will add in the new work from home contract that whenever they will go a wall, the employees in a day, they will be asked to pay a monetary penalty. Is this legal?
I mean, if you're a wall, I already said earlier that if you refuse to report for work, you cannot be disciplined for that. I mean, if it's in relation to COVID. But let's say, in another circumstance, in a world that there's no COVID, if you do not want to report for work, can you, I mean, say you just impose the normal penalties. I mean, suspend, verbal reprimand or written reprimand, and then worst case scenario, termination. But this is penalized for a specific amount, I mean payment, in addition to the fact that he or she is not paid for the day since a wall, and then you're going to ask the employee to pay. I think it's quite unfair. I mean, there's no Supreme Court ruling or anything, but of course, penalties must be fair and then commensurate to the act of the employee. Now, if it's merely a wall, I suggest you just impose the penalties and not which are not monetary in nature.
Yes. All right. Thank you, attorney. Down to our last question. Can we extend the forced leave of employees up to more than 6 months? Is it under our discretion as employers?
Forced leave of employees. So the 6 months is the floating in a floating status. So if you will go beyond 6 months, at least in the normal law, since our laws really do not contemplate the existence of COVID um, or other things similar in nature. So um, what the law says, that if it's beyond 6 months and they're still in floating status, you're still not giving them work. Um, it's either you pay them separation pay since you will be terminating their services at that point, or you may be sued for constructive dismissal. So the 6 months, as of now, there's still no law or directive that will allow for the extension to more than 6 months.
Okay. Thanks for the clarification, attorney. So I guess we have covered most of the questions. And here are some questions from our participants. If they will be receiving the copy of the presentation with the email address they used to register. Yes, Ma'am Sheila. All our participants, even our absentees for this webinar, will be receiving the link of the presentation and as well as the webinar itself. So I guess we had an overtime of almost 15 minutes. So again, we would like to thank Attorney Martin Luigi Samson for generously sharing his expertise and knowledge to our participants and viewers, most especially with the current situation and given the work from home challenges faced by different companies. Thank you so much, Attorney, and maybe hear a short speech to our employers.
Okay. First of all, if there's still other questions, or I mean, if you received the presentation and you managed to think of questions, you can email me, I guess, if you
Yes.
want. I'll be giving so it's mgsamson at
Okay.
accralaw.com. You can please include it in
Yes.
the email na lang for the
You can.
presentations.
Okay.
So,
All right.
as to any message, I mean, where most of the people here are either employers or part of the HR. So, as of this time, because of COVID, the name of the game really is survival. And then those who will survive are the ones who will adapt best. So please keep in mind that we have to do everything in order to survive. We're not merely we don't we're not merely going to try to survive for ourselves and for the business. We're also doing this for the employees and their families. So even small steps to help the employees, um, this will greatly benefit them later, especially down the line. So thank you again for the opportunity and thank you for attending this webinar.
Thank you so much, Attorney. So to our viewers and participants, marami pong salamat. Thank you for attending Mynimo Insights and stay safe always po. So for more updates on our upcoming webinars, you may visit our social media accounts, and I hope po to see you next Mynimo Insights. So thanks and have a wonderful afternoon, everyone. Thank you po. Thank you for attending our Mynimo Insights webinar. Thank you, Attorney.
Thank you very much, Shane.